we are back for the second session this Thursday afternoon, Principles of Property Law. So we are, this whole afternoon, we will be only concentrating on the law of contracts. As I've said at the beginning, please, it's going to be about 40% of the end of year paper, because we haven't done the 2 revision tests for me, but that's about all. So I will definitely be testing you in the end of year exam in this regard. So have a good look at that. Okay, people, we're talking about performance that must be possible. We had all these different, what did they call it, requirements, about what do we need for a contract to be valid. We've spoken about contractual capacity, and we've also spoken about the offer and how the other parties should be made known about your intentions or what you want to achieve here. So now we will look at the performance must be possible. Okay. So we are saying that a contract is void if performance was impossible right from the start. The example that I mentioned is, I want to buy your horse, and when I said yes, I did not realize that the horse died this morning. So there is just no ways, even though we have consensus about everything else is in place, there is no ways that I can now meet my obligation. So the contract will be void. It will be as if there was never any contract.
Can I use another
scenario?
Yeah. Let's say I buy a house and I sign the contract.
Yeah.
And there's an earthquake or whatever,
yeah.
and the house is demolished.
Yeah. Yeah.
Will the contract
be void? Yeah. Because it is circumstances beyond both parties. Vis majeur, an act of God, they call it.
But now the party that wanted to sell, he would be.
Well, we hope he's got insurance.
Okay,
yeah.
Have insurance.
Yeah.
Okay.
Yeah. So in other words, and that will put him back in the place where he was, perhaps he can then, or sell his vacant plot and put the money in his pocket or something like that. Yeah.
It will be void.
It will be void. Because it will now be impossible for the seller, to produce that house that you wanted in the first place. Then we can also, so void is, in other words, it is as if there were no contracts in place. Then we are also talking about voidable. So voidable is everything is in place for a valid contract. Everything is in place for a valid contract, but something has happened, and the parties can then decide if they want to continue with the contract or not. But I think I'm now sort of running ahead of myself, so yeah. So here it is just in terms of void, it is as if there was no contract, and here they specifically say it is impossible due to no fault of either of the parties. So in other words, what they call vis majeur or act of God. By chance, unforeseen or extraordinary circumstances. So there's a huge difference between lightning, strike the house, it burns down, and me, arson or something like that. Okay. Good. So neither party bears responsibility for the invalidation of this contract. Okay. Good. So if the contract was impossible right from the start, you cannot enforce it, because there's no base for this contract. Just cause, justa causa. Okay. Then we say the contract must be lawful if we want to rely on the courts to enforce it. So in other words, I cannot buy uncut diamonds and then run to the courts and say I have not been paid. I haven't received the diamonds and so on. Good. So that contract is then also void. There cannot be a contract because the justa causa, the just cause, the root of this whole contract is unlawful. Okay. So there they are talking where the conclusion of the contract itself is illegal. That's 3 categories. Where the performance in terms of the contract is illegal. Well, I'm thinking of, say, contracting perhaps to kill your spouse or something like that. Or where the cause or reason for its conclusion is illegal. Can you think of any examples where the conclusion of the contract itself is illegal, where the performance in terms of the contract is illegal? So I mean, it's legal for me to pay you, but for you to perform and produce uncut diamonds, that is then the problem. And the reason or the cause for its conclusion is also illegal. Yeah, so what we want to establish here is then illegal. Yeah, we're not always thinking of something sort of sinister, you know, but also perhaps, you know, employing people and paying them a minimum wage. There's something like that. Starting a factory or what they call it sweatshops, where you are from the start knowing that you are going to pay these people below minimum below minimum wage. So I mean, then obviously that operation will then probably be illegal, or that employment contract. Okay. Good. And yeah, so it's also a question of prostitution is still illegal in our country,
Last time
I never know because it's so openly, and yeah, but I think it is still illegal. But yeah, so sometimes it's not just a question of being on the books illegal, but it can also be against the moral values of, say, the community, you know, where it will be decided. Say, for instance, yeah, well, we just said, I think prostitution is still illegal. But yeah, where the sort of community sort of feels offended, you know, that contra bonus mores, against the good morals. Okay. Good, so we've now deal with the final 3 requirements of a valid contract. We must have serious intention. It's not just sort of playing games. My car's giving me so much problems, don't you want to buy it for 20,000? You get something like that. Or the performance must be definite, or it must be clearly defined, like that story you told us about you quoting on a set of plans, version 1, and in the end it's version 5 on which the building is being built, and you are now held responsible or accountable according to your quote, even though you quote on something else. Okay. Good. So yeah, we said, people, anything like that, why we have to first pay school money, we don't know. So please make sure when you are really into a serious contract, and remember, people, family, family can sort of dot your T's and just draw up a contract. That is why we have court cases, people, is because there was not a good contract, written contract in place. There was loopholes, and yeah, so if in this instance, for you that's out there, perhaps quoting in that side of the property business, insert that a copy of those plans into that contract, and especially, you know, the more informal it gets, you know, then if you're perhaps getting in a bakkie builder to build your bathroom, you know, make sure that you have good sketches there and that everybody signs, so that it's very clear for both parties. This is what I'm going to pay, but this is also what I can expect. In terms of finishes, the quality of those bathroom fixtures and things like that. Yeah. And then lastly, but the most importantly, there must be consensus between the parties. Okay. Good, so let's talk about the parties must have the serious intentions to create a legal tie. Here it is, that justa causa, the legal reason for concluding the contract. So this is an essential requirement. It must be serious and deliberate intention to bind yourself legally to the other party. And this justa causa implies that there's a basic valid reason, the intention of both parties to create a legal tie. Okay. Good, then, so if there's a deliberate and serious promise to perform, then also this, there's the intention to be linked to that promise, and the promise is accepted, then we have a valid contract between the two parties. Then we said the performance has to be definite or determined, or at least determinable. Okay, so say for instance I say, you know what, I would like to buy one of your racing horses, or perhaps one of the sons of, you know, this and this very good horse or cow or whatever. So, I mean, I can still now decide, or the seller can decide which of the offspring he will hand over to me, but it is determinable. I said this must be the sire or whatever of this animal, and that is what I want. So it's determinable. The moment I've made my choice, then it's fixed. Okay, but the contract was still there. It's not a void contract because it's indeterminate. It can be voidable if he gives me a horse and a cow and I've done a DNA test and I see, but flip, this is some other animal, So, okay. Or, yeah, and we spoke about this in terms of a house. How can I say build me a house of 2 million rand? And that's all I say. It is so unclear, it's so open for interpretation. There is just no ways that there can be consensus between the parties of what was agreed here. Just open for trouble. Okay. Then we also, with regards to this definite performance, there it is about a generic obligation or an alternative obligation. So we spoke about the alternative obligation. It can be any animal as long as the father is a specific horse or cow, no, not a cow, horse or a bull or something like that, or a generic obligation. There it's just said that A will buy a cow from B stock for a specific price. Okay, and unless otherwise agreed, the choice will be that of B, the owner of the animals, to select which animal he will hand over. Okay. People, then the parole evidence rule. What the parole evidence rule says is that everything is determined by the contract. That is why we have a written contract in the first place. It is not for the parties to come afterwards with additional photos or annexure to say, but we actually meant this, and this is what the idea was. No, the idea is that the contract should be able to stand on its own, and everything that is needed is in that contract. No, that is why we need it to be unambiguous. It must be clear, definite. Okay. Otherwise, we are defeating the object of a written contract if we can now bring all other kinds of evidence to the party. No? Okay, but then obviously what can happen is we call it rectification, to rectify the situation. Say for instance, afterwards the two parties now do realize, this isn't really what we had in mind. They can agree to rectify the contract to now, say for instance with regard to those building plans, version 1 you were quoted on, but now version 5 is the building that's going to be built. That you say we will now rectify the contract so that you can now include whatever specifications on that contract was changed. Okay. Good. Now the last one, there has to be consensus. No, consensus of the same mind between the two parties. Otherwise, there can be no valid agreement between the two parties. Okay. Then we obviously, that consensus between the two parties, obviously you must express that to the other party. No, it can be written, it can be verbally. We said, and at auction it can be a nod or a putting up your hand, anything like that. But it must be communicated to the other party, no, so that we know when this contract came into being. Okay. Then obviously it must be given voluntary, out of your free will and so forth. No, so we will have a look. Consensus will be influenced by 5 factors. No, first of all, people is contractual capacity. No, we spoke about that. Then obviously there's mistake or an error. There can be misrepresentation. In other words, I'm showing you a different picture than reality. Misrepresentation. There can be duress. I'm putting a gun to your head and say, you will sell your house to me. Something like that. Duress. And then lastly, there will be undue influence. Okay. Good. So mistake or error, there is a misconception or a misunderstanding between the two parties right from the start. For all I know, the developer, with regards to this house, perhaps he innocently thought that you want, it's a plot and plan development, perhaps he innocently thought or whatever that you wanted house A, but you actually wanted house C. So you can see there's no consensus between the two parties. You wanted a 2-bedroom and he thought you actually liked the 3-bedroom, something like that. So no consensus there. Okay. They say if the mistake does not materially affect the consensus, so the validity of the contract remains intact. Perhaps, who knows, say for instance now you rather wanted the red car, but it's now only a blue car, or they ordered the blue car, something like that, and you can live with that, you know, I'll throw in a tank of petrol, okay, everybody is happy. So then that would not necessarily affect the validity of the contract. But an error that affects the existence of consensus, like we spoke about, they are now building you a house that really it's not doing it for you. I mean, that is like a serious mistake. You cannot live with the consequences of that. You cannot see that you will be paying off on that house for, say, for the next 20 years. Or as we said, we don't know a solution to that one, but it is quite a disaster. So, okay. So the question here with a mistake will be, what is the sort of extent of the consensus, or how far is consensus now affected? If I can live with a blue car, thank heavens, okay, so we still have a contract and you will be going home with a new car. But if that mistake between the two is of such a material nature that the other party is saying, you know what, I can't live with this, then obviously that will have an effect on the validity of the contract. Okay. Here we have our void, or I thought we are going to, okay. Void or avoidable contract. We spoke about that. Void means a contract is void right from the start. It is as if there was no contract between the two parties. And there we will look at all those factors that bring a valid contract into existence. Okay, so a voidable contract would be where there's been misrepresentation. In other words, I am telling you, off plan, you can buy this flat in Durban. It has got unlimited sea views. And it is just fantastic, or whatever. You get there, and there's no sea view, it's in a seedy part of town and so forth. No, brochures look not at all like the reality. No, serious misrepresentation, plain lying. No. So in other words, you are saying, you know what, there has been no consensus. If I knew this is what this building looks like, this is going to be the view, this is my neighbors, I would not have bought here in the first place. Okay, so I want this contract to be terminated. Okay. Okay, where there's been force or fear or intimidation, people obviously, for that moment, there might have been consent because you did it under duress, out of fear for your life. But I mean, if that revolver wasn't in the room, you would have said, no, I'm not selling. Okay, so the moment when that is now removed, you can come and say, you know what, I feared for my life. I thought I was going to die, that's why I said you can have it, but no. No, I'm saying no. Yeah. Okay.
How can you prove that?
Yeah, I wonder, and why do you have the guts now, you know? Yeah. Sure, how can you prove that, I would think if this guy is a known wanderer of the underworld, you know, perhaps people will believe, you know, that he can do stuff like that. But yeah, sure, it will probably be a difficult one.
Yeah, because there were only two people.
Yeah.
Well, that's why you have, on all contracts, you have a witness that has to
That's
sign.
true.
So probably
that's true.
Why.
But it's not his two bodyguards.
Yeah.
Yeah.
Okay.
Yeah, it's a difficult one. Okay, where there has been undue influence. Now people, yeah, I mean, that, you know, probably happens a lot more. You can have a doctor-patient, or an attorney-client relationship, where the one party has got a certain influence over the other party. The one always comes for advice, or the patient is sick, frail, ill, scared, you know, and the stronger party makes certain suggestions. Why don't we sort out your estate? You sell the farm to me, and then the children inherit cash, and everything is sorted. You know, things like that. And then afterwards you can say, you know what, the doctor had undue influence over my father, that's why I sold the farm for below market, let's say that, below market, and if it wasn't for that relationship, my father would not have sold. Something like that. So it is in a position where a trust can be abused. So we will be saying that that type of contract will then be voidable. Okay. Examples of a void contract. Yeah, so in other words, with a voidable contract is that the prejudiced party will always have a choice. He can perhaps say, I sold my house under duress, but it's fine, you know, let it go, sort of. I'm not going to revisit it or whatever. So there is a choice for that party. But where it is void, remember, it is as if there's no agreement in place, there's no leg to stand on, no justa causa. That is contracts that cannot be performed for reasons beyond the party's control. The house struck by lightning, it's burned down. I'm sorry, there's no property that I can rent to you or building. Illegal contracts. This is contracts prohibited by statutes or contracts contrary to good morals and contracts contrary to public policy. Okay, so something illegal there. Then contracts concluded by persons who lack contractual capacity. So minors under the age of 7, insane people, or people that's drunk or under the influence of drugs and so forth. Okay, so that is void contracts, people, because it is directly going against the factors needed to put a valid contract in place. Okay, and then also contract subject to a reasonable and essential error. Okay. And again, a void contract, there is no serious intention to create a legal tie. Okay. Okay, we spoke about it when we'll get to damage now, yeah. Okay, then rights and remedies in respect of misrepresentation. Here we can have rescission and damages. Rescission means that they can put that contract aside, that if the representation led to the conclusion of the contract. So we said you are buying this flat in Durban unseen, but you now want to rescind on that contract, because if you knew the real circumstances, the real condition of this property, you would not have signed in the first place. Okay. Okay. So here in Davidson,
let's say you buy this flat and it looks nice, and in 2 months' time the paint starts falling off because of water damage. Can you then go back and say, but you didn't know about it, you weren't informed? How can you?
I think then you would only, remember I'm not a lawyer, I think the only leg that you would have to stand on would be if the seller knew that there was waterproofing problems, and he was, he sort of, what is it, cosmetic, he made some cosmetic improvements here to be able to sell it to you, and then I would think that you would be able probably to flip. I don't know if you can be said, but probably, because it is a major element that he needed to declare to you. People sometimes rely on the foot stewards clause, but foot stewards only means that it is there's problems that none of the parties are aware of. So both is in good faith. Okay, but in this instance, you will be trying to hide the fact that there's waterproofing problems by having a paint job done, and so then you can't rely on that. Because again, you would not have bought it if you knew that there was a waterproofing problem that nobody can solve, say for instance.
But there should be a clause that says within this time you'll have to. You can't go after 10 years and say.
Well, no. I think that is again the reasonable thing. As you are saying, within 1 or 2 months, the paint starts to bubble because of this lingering problem. Then I would say you have a very strong leg to stand on. One of the East London students actually told me that they bought a house, I think in East London. Well, I can't think that it's in the. She'll probably hear me and then she can clarify. But after they bought the house, they realized that somebody was buried on that plot. And she said they would not have bought it if they knew about it. And I said, I also again didn't know if you can, perhaps you can ask your husband, but I don't know if you can go back on the contract, but I would think from a professional side, that estate agent must be reported, because he must have known. If I disclose the fact that somebody is buried on this earth, people may not buy it. Or perhaps people will buy it, but then they would like a good reduction in that sales price. We've now just compared it with other properties and that looked fine, but then obviously if I can get it for say 100,000 less, I'll buy it, say for instance. But then at least you have made an informed decision. So, so I would again also think that is a major misrepresentation there. Or not even misrepresentation, because, you didn't, that you present it as just an ordinary property like all the others, Okay. Here it says, Davidson versus Bonafide said, Davidson withdrew from the contract and claimed restitution of the purchase price, interest paid on the deposit and the bond, as well as necessary expenditure for the improvement of the house. B is entitled to receive compensation with interest for the period for which Davidson had the use of the house. Davidson used the house by letting it, and Bonafide was entitled to this rent with interest. No. So that is the resultant position, was that both parties were brought back to in the position that they were before they concluded that contract. Okay. As if there has never been such a contract. So we want to sort of put everybody back sort of in time where they were. Okay. Then damages in the cases of intentional or negligent misrepresentation. Damage may be claimed, but in the case of innocent misrepresentation, no damages will be granted. Oh yeah, as you was now saying about the paint job, perhaps then you can, because as I said, the seller will definitely know about this waterproofing problem. Then perhaps you can now claim damages from him that he must now obviously rectify the problem. Which one wouldn't understand why didn't he do it in the first place, and you know, people, on the other hand, it's all good and well, but who has the money to approach the courts, you know, to in this instance, to sort this out? No. Obviously, one can approach the small claims court. I think they have a limit of 15,000 rand. So, but yeah, who knows what a waterproofing problem is going to cost, you know? So yeah, so that is the other reality. Okay. Goed. So
yeah,
if the
sorry, ma'am, another thing, or the same scenario. Before the bank borrows me money to buy this flat, they will send out a valuer, or not?
Yeah.
In all cases.
As far as I know, in all cases.
So then the valuer should have said the bank shouldn't borrow the money because of waterproofing. Can they hold the valuer?
Probably responsible, you know, because it was negligent on his side. If it's something that he was supposed to be able to see, it's not a latent defect. So if he saw there was waterproofing problems, he sort of spoke to people. They said, you know what, that has forever been a problem because of this and this, you know. Perhaps it's a walkway, you know, at the top of the flat, you know, and because of poor waterproofing when they built it, you know, it's always going to be an ongoing process to try and rectify it, you know. Then I would think definitely the valuer should make the bank, you know, take photos of that and make the bank aware of that. Yeah, no, definitely.
So there can be a lot of people involved. Or
no, definitely. No, definitely. I remember years ago, I also needed to value a flat, and I mean that place also had huge damp-proofing problems, you know, literally where there was mold in it, you know, it was so damp that there was literally mold in that. Now obviously, you know, you will bring that to the attention of the bank, and then they can decide. You still value it with that defect, and the bank can then decide, you know, how they want to spread their risk there. Yeah. Okay. Good. Here it is, another one, Ranger versus Weikert said Ranger decided to uphold the contract and to just claim damages. He paid more for the house than he would have liked if he was sure about the true state of affairs, or like that body being buried on the earth. but he nonetheless would like to keep the house. So the action that Ranger took was based on a delict, and for this reason he was entitled to be reinstituted into the position that he would have been had the misrepresentation not been made. Yeah. Okay. No, so as I said, you know, if somebody told you there was a body buried here, I would have said, you know what, I'll pay 50 or 100,000 rand less, take that offer back or whatever, and at least then it was my decision. Hey, so now I'm going back and I'm saying I want to claim that money back, because I would not have paid comparable sales price if I knew about this. Yeah. Okay, then duress. This is compulsion by intimidation, or creating fear in a person. And it can actually be any form of violence, injury, or threat of injurious consequences, which forces a person to conclude a contract against his own free will and choice. Well, I was now just thinking, what about the movies we've forever seen, how the hero is holding a gun to somebody and saying, I want to take your car, I need to do a car chase here, and you are saying sort of yes, and giving him your car and get it back in 10 pieces, something like that. Then you can say, but I only gave the car because I was scared for my life. But yeah, this is not what I wanted to do. So here, a material show of violence or injury, or a reasonable fear, even a reasonable fear of the affliction of violence or injury. The threat or intimidation must directly or indirectly entail a considerable threat of some serious evil for that person. It must have been inescapable, and obviously that threat must have been unlawful, or against the good morals. Well, we will think so, yeah. Okay. The person is not bound by a contract if he is induced to agree, by duress. Okay. Because he does not act on his own free will. Okay. In undue influence, we spoke about that exploitation of a trust relationship between people. Okay. So in Praller versus Jordan people, we just talking about the court cases here, but I do not expect of you to know names of court cases and things like that. It's just little interesting stories in between. Okay. Here it said it was argued that the doctor had misused his position to persuade an elderly man who was in poor health to transfer 4 farms to the doctor, who then went and transferred 3 of those farms to his children. That klinkt somewhere. Yeah, that sounds somewhere very, very scary. Okay. The court then decided that the contract was voidable on the ground of undue influence, and that the remedy of restitutio, restitution, in integrum would be applicable. A victim of undue influence may withdraw from the claim and claim restitution, but he is not, however, entitled to claim damages. So you can just say, I want to be returned, or my property needs to be returned. So perhaps, remember, it's voidable. So say, for instance, the children of this farmer says, but we don't actually want the farms, and perhaps the price was perhaps reasonable, or livable with, then you can say, what, it's voidable, but it's fine, But if they now feel, no, it was done below market value, so then we want that restitution, we want the farms to be given back. Unenforceable contract, we spoke about that, that is obviously where it is, the court will not enforce it. It's an illegal act that happened. Now, just because you are now without the money that you paid for the uncut diamonds, the court is just of the opinion that it is your problem. It is sort of also to put people off of criminal activities, to know, what, if you are part of criminal activities, do not expect that the legal system will help you in those matters.
Except if your surname is or something.
Yeah, practice. Yeah, no, that is, cannot actually understand that, but I see that apparently they are doing now something about a PIC, you know, because I just thought, how is it possible that everybody's talking about the pension fund going to be raided and nothing is happening? Yeah, so that's good news. Okay. Examples of these unenforceable contracts, there would be agreements concluded by minors between the age of 7 and 21, sure, I don't know about the 21 yet, and without the assistance of their guardians, probably over 17.